All right, so we're at 2 o'clock. Let's get this thing started. It's my pleasure to welcome you to this webinar. My name is Ben Alarie, and I am a professor here at the University of Toronto Faculty of Law, and I'm also the CEO of Blue Jay Legal. And so really pleased to be bringing this webinar to you this afternoon. Today, our topic is about predicting judicial decision-making with machine learning, with a particular emphasis on examining a particular issue that comes up very frequently in the context of value-added taxes, or here in Canada, what we would call the GST, HST context. So what is it that we're going to be talking about today? What we're going to be talking about is how can you tell the right characterization of a transaction when you have multiple elements that are being supplied by a taxpayer, a GST, HST registrant. So you've got a supply being made and there are multiple elements, but the question is that one thing or is that multiple things? And so this is an issue that all VAT regimes need to confront and need to have an answer for. It gets litigated very frequently. One of the reasons why it gets litigated so frequently is oftentimes different elements of a supply will have different tax consequences associated with them. So sometimes some supplies will be zero rated, which means that in theory they're taxable, but what applies is a 0% rate to that supply, which is important that theoretically it's taxable because it means that any of the inputs that you spend money on, you can claim input tax credits for those elements that contribute to that zero-rated supply. So exports are a good example, but there are a number of zero-rated supplies also domestically. The other big category of things that aren't just regular taxable supplies would be exempt supplies. And so with respect to exempt supplies, in theory, they're not taxable at all. And so you can't really get input tax credits for them. And so a lot of times these issues come up. Taxpayers want to bundle certain things where that's more attractive, associated with better tax consequences. Sometimes it's the tax authorities who want to bundle things and claim that something's a single supply, if by disaggregating them and claiming that it's a multiple supply, the taxpayer is claiming additional tax benefits. So these issues can go both ways, and it's an issue that comes up all the time. We're going to use Tax Foresight today to analyze a particular case, a recent case that was just decided last year here in Canada on the single versus multiple supply question. We're going to see how you can use machine learning to figure out exactly what a court would likely do in these circumstances. So I'm going to step you all through that case, and we'll get into the details and how that actually works. Before we get into it, I think it makes sense to provide not tax technical context, but instead some machine learning context. Where are we in this arc on tax research, in this journey towards fully fledged AI and the legal singularity, as I would call it, where everything is just kind of known and we just don't have the same pervasive legal uncertainty that we face now. We're not there yet. We're working hard at Blue Jay Legal and also at Thomson Reuters to get to that place of understanding everything and using computational legal research to really peel back what the law requires in all sorts of different domains, but we're not nearly there yet. So what does this journey look like from our perspective, from my perspective? What it looks like is when I started law school back in the 1990s, a very long time ago, almost all the research was being conducted out of books, out of law journals, out of reporters, case reporters, other loose leaf publications. And librarians actually had to go and change out the pages and binders of documents to keep them current. And so we've moved very far past just relying solely on physical media to deliver legal research content, tax research content, and now a lot of it is digital. And this was happening in the 90s when I was in law school. We had these big CD-ROM towers in the library, and you can access what seemed like an amazing amount of information on these CD-ROMs. And that happened, started happening many years ago, 25 years ago, Now we're like all fully quite used to this idea of accessing so much of our materials online. You know, the books aren't dead. So here's my version of the Canadian income tax law book that I'm co-author on. Well-worn copy. I use it for teaching. Books aren't dead by any means, but so much of this stuff has moved into the digital realm now, and you know, lots of advantages. You can find stuff much faster. You don't have to fight for copies. So if a book's out of the library, you know, that used to be the end of it. You just had to wait patiently for that book to return. No longer the case with digital materials. Multiple people can access the same content simultaneously. Keyword searching, all sorts of hyperlinking makes it way easier to find stuff. Computational methods for finding materials are suggested by some of the things I said about digital. So hyperlinking, right? You know, follow a link, that requires following some instructions. There's something there. What I have in mind, though, when I talk about computational legal research is going a step further. So taking the content in those digital documents, synthesizing it, understanding it, extracting the information using algorithms and machine learning and AI technology to really make sense out of the concepts, out of the information contained in those digital resources. And so it's about leveraging the fact that we have a lot more computing power at our disposal now. We understand better how to use algorithms to extract information automatically from digital content. And we just have a lot more of the content digitized. So a lot of the information is now available digitally, and the courts are publishing their judgments in digital format online, which makes a lot of this stuff a lot easier to get your hands on in terms of so you have the raw materials, the stuff being made available digitally. You've got the algorithms, kind of the formulas for figuring out the information out of those materials. And then you've got the computing power to actually implement and solve a lot of those things. So that's what I mean by the computational move into legal research. And as I suggested a few minutes ago, where this ends up is actually in what I think is the legal singularity, and legal answers are just, you know, available everywhere all the time. And I've done a little bit of writing about this. So if you're interested in geeking out in a sci-fi way on what the legal singularity actually means, I suggest you Google it. Okay. So thinking about how this works at each of the stages, I'm not going to belabor this, but you know, there are different things that you do when you are providing advice to a client. If you're an accountant or if you're a lawyer, you're going to go through these stages. First, you want to find all the relevant cases, the relevant source materials that have some bearing on your analysis. You'll want to gather together those important legal materials, and then from there, figure out the most important legal questions to ask. Then you're going to basically take your understanding of the law and gather facts from your client and apply the law to your particular facts. So you're going to spend a lot of time reading a whole bunch of materials, whether you're finding them analog in books or digitally online. And then you're going to basically read around, try to understand what the law requires. And then you're going to look at your client situation and say, okay, I think given what I know about the law from that research, I'm going to apply the law to my client's facts. Our approach to this computational question kind of turns that on its head. So our classifiers, and we'll get into this, we'll do an example, actually asks us questions about the client situation. So what's actually going on, and we'll target questions. So it's going to elicit from us the information necessary to make a prediction about how a court would actually analyze that legal situation based on all the case law. So the big move in this computational turn is to say, you know what, court judgments are actually data. Judgments are data. We need to treat judgments as data and figure out what those data points actually mean for us with respect to our analysis. And so one of the big advantages of this computational turn is you're going to be armed with all the stuff you need to have on hand to advocate for your client situation. So you can get a really objective approach to the case, but you're also going to have the tools available to advocate strongly as possible for your client's position if that doesn't happen to line up with what the courts are actually saying in all likelihood in your client situation. So here's what our users tell us about using Tax Foresight. They tell us that it allows them to produce the highest quality advice. So it helps by providing a checklist of nothing else, like even just the questions that Tax Foresight is asking with respect to the legal questions that it provides predictions for. Even having that checklist, making sure you don't miss anything is very, very helpful. Others say, it allows me to produce the highest quality advice, but it also, how it does that is it allows me to spend more time on the trickier aspects of the advice, and I make sure that I'm not missing anything. So something that used to take me 3 days now takes 30 minutes, or I can find the cases that have exactly those features that I know I need to advocate for my client immediately using Case Finder. And I'll show you Case Finder in the course of the webinar today. People find that it saves a lot of time, and it makes sure that they really aren't missing any of the most germane authorities, which is something that we all have a professional responsibility to attend to as lawyers and as accountants. And so is very, very important. I said earlier that the classifiers allow you to get a sense of what the objective merits would be of your client's situation, and that's something that clients really, really value. So one thing that we hear from our users is that my clients are always asking me to try to quantify the risks that they might be taking on in adopting a certain position vis-a-vis the government. Or our users in government say, I often struggle to figure out what an interpretation bulletin or a folio means for my clients, or for a taxpayer situation, and I'm left kind of not really knowing what would happen if this were to go up on appeal, either internally through an appeals process internally, or if it ultimately ended up in court, what would actually happen. And so one of the really great things is using this kind of software, you can synthesize the findings of all of those hundreds of judgments on that particular question that have been analyzed before by the courts, that right now it'll be hit and miss. You can't read everything. No one can keep up with all of the case law as it gets decided. You can analyze all of that stuff and basically get a very good prediction of what a court would do by leveraging all of those judgments, which are actually data. And finally, it's independent analysis, right? So it's an objective take. It's if regardless of who you are, if you're in government or if you're in private practice, or if you're advising in an in-house position, you're advising your employer about the tax position that your employer's in with respect to something. If you answer the questions in the same way, if the factual situation is presented the same way to the software, it's going to produce the same answer. These algorithms are not partisan, they're independent, they're leveraging the case law as data. And so one of the problems with human experts, and it's a feature of our neurology, it's very difficult for us to transcend our neurology, transcend the fact that if you're being approached in private practice by a client who really, really wants an outcome to be a particular way, that's going to color your judgment as you're working through the case law, as you're producing your memo. It's inescapable. All these biases are going to creep into your analysis. The flip side is, if you're in government, oftentimes, you're not, who's buttering your bread. And so it can be a challenge to actually stay totally neutral, despite our best efforts and despite our professional obligations to remain as neutral as possible. It's not a fault of anyone. This is just naturally what happens. There's tons of evidence about motivated reasoning that could be given, and it's a consistent finding by research psychologists that we do exhibit motivated reasoning, and just through simple things like confirmation biases, right? So if we expect a certain outcome, we're more likely to tune in to the particular evidence that supports a particular view of a situation. And it's true. It's a persistent feature of our neurology, which means that using software that can provide the same opinion regardless of which side of the aisle you may be on with respect to a particular question is actually really, really valuable as a way to diagnose or calibrate whether or not you're falling prey to some biases. So it's a way to satisfy our professional obligations to remain objective be a zealous advocate for your client, yes, but also provide informed legal advice or tax advice, depending on the particular situation of the professional. Okay. So today, with that background, so I gave you a little bit of the background about the law in this area with respect to this question at the very outset. Then I gave you a little bit of context about where are we in this machine learning journey anyway? Are we at the legal singularity, or not? And the answer is no, not nearly. But we've got some really great machine learning tools that are representing the front end of the shift into computational legal research. So let's bring this down to earth a little bit. Let's get into an actual situation that comes up all the time. And so the research question is this: does a transaction including different elements consist of a single supply or multiple supplies for GST, HST purposes? I was chatting, and I promised Frankie that I would talk about this in the webinar today. I was chatting with my 6-year-old daughter, Frances, this morning. And she said, "Dad, what are you doing today?" I said, "Oh, I'm really excited. I'm doing a webinar on single versus multiple supply." And she said, "Well, what's that?" And I said, "Well, it's this thing that comes up in tax all the time. It's a big question." She said, "Well, what's a single supply, multiple supply? What is it about?" I said, "Well, here's an analogy." And I said, "Do you think a tea set is one thing or multiple things?" And Frankie said, "It's one thing." And I said, yeah, but why is it one thing? Because you have, the teacups, you have the saucers, you have the spoons, you have the teapot, you've got all the different pieces here. You got the lid to the teapot. And she said, "Yeah, but it comes all in one box when you buy it at the store." And I said, "Aha." And I said, you're right. That's probably the answer that a court would come up with. It's amazing that you know. And she felt very good about that answer. And she said, "You should give that example in the webinar today." And I said, okay. I said, I will, because it really does point out this is philosophically a very, very common kind of problem. When is something one thing versus many things? This is really, really persistent. And this is a deep philosophical question. It doesn't have a single philosophical answer, I don't think. Even our word for everything, the universe, is the universe one thing, multiple things? It depends for, which purposes are we asking this question? Is something a single thing or a multiple thing? So let's look at how the courts look at it in this particular context with respect to tax liability for GST, HST. So just to ground this, that's what we're talking about in this context: GST, HST purposes, and similar reasoning in other VAT systems. Okay, so what we're going to do is talk about this very specific case. What are the facts? I invite you to read along, but I'll just describe the situation fairly straightforwardly. So this is the taxpayer is a corporation. It's a professional corporation. It's licensed to provide dentistry services in Ontario. And the taxpayer hires and provides services through Dr. Brian Hurd. So Dr. Hurd supplies orthodontic services. And so that's, braces for those in the old school like me. And essentially how this works is there's an initial examination. You kind of go in and you talk to Dr. Hurd, and Dr. Hurd takes a look at your impressions, takes a look at your mouth, and says, okay, what are you hoping to achieve with these services? And has a conversation with the patient, and it goes back and forth. And then Dr. Hurd makes a recommendation about a treatment plan and the right appliance that would achieve the objectives that the patient and the professional in this case decide on together. And so they decide on this appliance. He answers all the questions that they may have, and they agree on a treatment plan. And so over the course of a period of time, it could be months, it could be years, this patient interacts with the dental practice and interacts with the appliance and gets serviced a number of times over the course of the next couple of years in accordance with that treatment plan. And so the orthodontic appliance and the treatment plan and the services linked to the treatment plan are invoiced in a single agreement, and there's a single lump sum consideration paid for those services. So it's very clear up front that these things are linked in this agreement. The orthodontic compliance is separated out in an itemized way in this agreement, and it is said in the agreement that it's subject to the contract. It's allocated 35% of the total fee to comply with a CRA directive requiring the cost of the appliance to be broken out, and also for accounting purposes for the practice itself. The various services that are part of the treatment plan are essential in achieving the objective of the plan. So the appliance on its own is not really particularly useful unless you link it with a treatment plan, and the treatment plan is not useful unless you have the appliance. So they're linked in that respect, that you need to have both an appliance and a treatment plan to get the value as the end user of these services and the appliance. You need a bit of both in order to make things work. So here, the professional corp claimed that the appliance as a zero-rated supply and the maintenance and adjustment services, so pursuant to the treatment plan, were multiple supplies. Why would they want to do this? Well, if something, and this goes back to the beginning, if something's a zero-rated supply, you can take input tax credits with respect to the cost of making that supply. If something's an exempt supply, you can't take input tax credits because it's just kind of out of the GST-HST input tax credit system entirely. So philosophically, they get different treatments, and so it's not as good for the corporation to be in the position of making a supply that's a single supply if that entire single supply is going to be characterized as being an exempt supply. So the way that the professional corp here was approaching this situation was, no, 35% of this agreement is a zero-rated supply, and so that would have permitted the professional corp, if that was regarded as a separate supply, to then give rise to the ability for the corp to claim input tax credits. And so the minister resisted that characterization, said, no, this is a single exempt supply of healthcare services, and therefore all exempt is how we're going to characterize it, was the minister's position, not at all a zero-rated supply. So the minister reassessed the taxpayer, denied the input tax credits for the period at issue, and the taxpayer appealed to the court. So if you want to read the full judgment of the court, you can go to this case, Dr. Brian Hurd Dentistry Professional Corp. and the Queen, 2017 TCC 142. Now, what we're going to do is look at how you might have analyzed this if you were advising this professional corp, many years ago, on how they might approach this particular situation. And so I've logged into Tax Foresight here, and what you'll see is this is the platform. So this is how you could analyze the situation. What you would do is type in the quick find bar here. You see I've got single versus multiple supply under my favorites, and it's also coming up under the indirect tax button here. So I'm just going to click on the classifier, and it's going to take me into the single versus multiple supply classifier. So gives you a little bit of background on this initial screen. Explains that we need to basically answer a short questionnaire about the situation, what it's trying to do, the sorts of issues it's addressing under the Excise Tax Act, specifically Section 123 of the Excise Tax Act, and then we'll get to a prediction about how a court would probably analyze this kind of situation. So here we are. We're in the software, and we can see it's going to ask us 13 questions. That number can go up, so there's some path dependency here. We may have to answer a few more questions. Maybe 13 will be all we need to do based on how we answer these questions. So it's going to first ask a number of questions about the underlying transaction. So remember, this is this agreement between a patient and the professional corporation that's delivering the orthodontic services to that patient. We'll look into the use of the elements. So the different elements here are the orthodontic appliance itself, and then the services provided according to the treatment plan. We'll look to the supplier's practices, and then we're going to get our prediction about how a court would likely analyze the situation. So What best describes the elements of this transaction? Well, it's a mix of property and services, because we have an appliance, that's property, and services, the treatment plan. What best describes the industry in which the transaction took place? Here it's health and personal care. I don't think it's any of these other ones, so I think we can click multiple if we need to, but just it's healthcare. Was there more than one contract between the supplier and the recipient for the elements at issue? No. There was just the one agreement between the professional corporation and the patient. Was there a separate charge for each element of the transaction? No, it was itemized out, but let's see. Distinct treatment on the invoice, fee schedule, sales contract, or similar financial documentation is an indicator of separate consideration, weighing in favor of a finding of multiple supplies. Okay, so I'm going to say that there was a separate charge for each element of the transaction. What we're going to do is, as we go through, I think that's the right answer, because I recall there was a 35% fee allocated to the orthodontic appliance. So yes, there was a separate charge for each element of the transaction. Could the recipient have declined to purchase one of the elements? No. The professional corp was not in a position to sell an orthodontic appliance without also providing the treatment plan and the services. So that was a key part of the relationship between the patient and the professional corp. 1.6, did the recipient have a choice as to one of the elements from a variety of options offered? No, not really. The treatment plan is going to be the treatment plan. There would be some negotiation about what the treatment plan looked like, but it wasn't really, it wasn't a long menu of different orthodontic appliances, for example. Instead, it was really, no, you need the appliance that's appropriate to your desired objective here. Okay, so the answer to 1.6 should be no. All right, we'll click next. Could each element be purchased separately and still be useful? Here the answer is no. You need the appliance and you need a treatment plan. Was the purpose of one of the elements to prepare for the use of the other elements? Yes, I think so. So you need the orthodontic appliance in order to have the treatment plan make sense. So that's true. Was one of the elements specifically designed to work with the other elements? Yeah, for sure. So the treatment plan is totally tailored to the particular kind of orthodontic appliance that the dentist thinks is going to actually advance the patient towards the desired objective. Did the recipient use the elements contemporaneously? That means at the same time. Yes, absolutely. They used them at the same time. Okay. So now we get to some suppliers, practices, questions. If the elements are goods, were they physically packaged together? Well, here the elements are not all goods. So we say that 3.2, was there a legal or regulatory reason why the elements were supplied together? No, not really. I think you could argue this one. So I think if I were wanting to argue that yes, there was a legal reason, I think I might say, well, if I'm providing these services as a medical professional to a patient, I want to make sure that the orthodontic appliance is being used appropriately. It's not being misused. I don't want to be in a position where I'm made responsible for something that could have gone wrong in the patient's care if they are misusing the appliance. So I think I might say there's an argument that you could say yes here. There's a stronger argument that I think you'd say no, there's no requirement that they have to be bundled. Let's see what the tooltip says here. So the tooltip says, if there's a legal or regulatory reason why the elements are supplied together, this may make a finding of a single supply more likely. For example, if accommodations in personal care are provided together in accordance with the regulations that govern personal care homes, select yes. If admission to recreational trails and agricultural products are provided together to comply with rules that limit commercial use of agricultural land, select yes. If a medical practitioner is required to administer a vaccine, there is a regulatory reason for the administration of the vaccine itself to be supplied together. Select yes. So the question here is this orthodontic appliance more like a vaccination, like a dose of vaccine, or is it something else. And I think you could probably source an orthodontic appliance independently of the services. I don't think it would be illegal to do that. I don't think it'd be contrary to any statute that I'm aware of. So I think it's a little bit debatable, but let's say no, and then we can come back and change it to yes and see how that affects the result. Okay, question 3.3. Do direct competitors of the supplier sell either of the elements independently in the ordinary course of business? Okay, let's see. If a competitor supplies the elements independently, this suggests that the elements are not intrinsically connected and therefore are multiple supplies. For example, if the taxpayer sells taxidermy services together with taxidermy materials, but competitors sell the services and materials separately, so select yes. For greater clarity, if the competitor only sells one of the elements, this is considered supplying that element independently. Select yes. Okay, so I assume that this dental professional is acquiring the appliances themselves. Sometimes, at least the raw materials for the appliance from another supplier, and so there must be somebody selling just appliances, probably directly, predominantly to orthodontists, right? So the right answer here is yes, somebody's selling some of these things independently of each other, because when the orthodontist is acquiring, the orthodontist professional corp is acquiring the appliance, or at least the parts of the appliance from a supplier, surely that supplier is not requiring that they also pay for a treatment plan. So there are some other suppliers on the market who are selling at least one of these elements independently. So the right answer to 3.3 should be yes. Okay, so looks like we're done. What we can do now is click on compute and find out how Tax Foresight would analyze the situation. So when I click compute, the system's going to take all of the answers to these 13 questions, compare it to all the decided cases in this area, and come up with its best prediction about how a court would decide this particular set of facts. So let's see. Okay, so a very, very strong prediction from the system here that this set of responses would be characterized by a court as constituting a single supply. In fact, a 94% confidence that a court would say single supply here in these circumstances. So this is interesting. So what you see here is the predicted result and the confidence of the system and an explanation about why that's the outcome. And we'll drill down on this a little bit in a second, and the identification of the most similar cases that have been decided by the courts with these particular attributes. Okay, so let's see more here. Okay, so this explanation is the product of its own algorithm. So we've trained an algorithm on the state of the prediction algorithms and all the various elements here, and this is produced to provide insight into how the first algorithm is actually deciding this case, so or making this prediction. So it gives you a little bit of context about the situation here, talks about the specific transaction, the use of the various elements, the supplier's practices, and contextualizes what the prediction is here coming out of the algorithm. So it identifies also, this result screen identifies also the most similar cases that have been decided. And very, very interesting here that the most similar case that's been decided is Dr. Brian Hurd Dentistry Professional Corp and the Queen. So that's the case that we've modeled our answers on. And you'll see here, it's no surprise that the algorithm is coming up with this 94% confidence score here, not least because among the most similar cases, all of them have said this is a single supply. So let's just take a peek here. So Leisure Paths Group Limited, this is a UK case. In that UK case, what we see is that there are a number of very similar factors, and then some factors that are dissimilar, right? So in that case, there was not a separate charge for each element, and the elements were not specifically designed to work with each other. So one of those dissimilar factors, a separate charge for each element, was absent in that case, which would seem to indicate that it's more likely to be a single supply. The other one, elements specifically designed to work with the others, was not present, which would seem to militate in favor of a multiple supply. So those dissimilar factors are ambiguous, which is probably why, and it's got a ton in common with our situation here. No surprise that it comes out as single supply, but the uniformity of these similar cases all pointing to a single supply means that the algorithm is pretty confident that if this case were to come to court, it would go in the direction of single supply. Okay. System also identifies the leading cases on this question. So these are not necessarily similar cases to the facts of the case that we have here. Instead, these are the cases that get cited most frequently. These are kind of regarded as the most relevant cases when courts are looking at this question of whether there's a single supply or a multiple supply. One of the things that we can do now that we've reached the results screen is we can download a report. So just clicked on that download report button, and this is going to download, and I can show you what the report looks like. So users of the report get this nicely formatted result. It explains, it identifies the prediction, it identifies the confidence, it gives an explanation of the result, it gives an explanation of our data and methodology. It identifies the most similar cases. We can link out directly. It links out. So when I move over any one of the case names, you'll see that it's hyperlinked. Tells us at a glance whether it was a single supply or multiple supply case. Then really importantly, if I were to file this with my client's information, I would want to know what were the specific questions and what were my specific answers that I delivered to the system in order to generate this report. And so this provides a nice audit trail for me personally to go back and assess whether or not I answered these questions appropriately, and therefore, it seems reasonable to rely on this particular prediction. Okay, so I'm going to close this up. One of the things that we can do is go back and do some scenario testing here. So I can go back and say, okay, let's see about this question 3.2. So remember, 3.2 is this question about whether there's a legal or regulatory reason why the elements were supplied together. And we said no. We can also say yes. So we might say yes if we want to analogize to this question about, is this orthodontic appliance similar to a vaccine that has to be administered by a physician? If you want to say, it'd be irresponsible or tantamount to professional negligence to just, sell a patient directly an orthodontic appliance, you might say that. You might then try to argue that that was a legal reason why the elements were supplied together, the elements being the treatment plan and the services associated with the treatment plan and the orthodontic appliance. I might make that argument. If I were the physician in this case, I might say, yeah, actually, those things are really linked together. It would make me feel reckless to not actually also service the orthodontic appliance together in conjunction with this treatment plan. I want to be kind of a full stack provider of these services in this situation. Okay, so I'm going to click recompute. We can see how this change influences the result. Okay, so it doesn't really have much bearing at all. So that actually doesn't bite on these facts. What it has done is it's changed the most similar cases. So now suddenly we see the Calgary case coming to the fore here. And we see the actual case that this was based on actually come out a little bit lower because there was no regulatory reason why the elements were supplied together. What else could we scenario test here? Okay. Could you argue that you might be able to purchase these things separately and still be useful? If I were a resourceful patient and I found the right orthodontic appliance and I bought it online and had it shipped to me, and I showed up at this orthodontist practice, I said, can you please treat me? Can you come up with a treatment plan? I want to use this appliance. I brought my own appliance. Can you help treat me using this appliance? Do you think that might still be a useful exercise? Arguably, right? Yeah. So if you showed up with your own appliance, your own parts, maybe you could do that. I mean, it seems pretty unrealistic that a patient would do that. I don't know if that happens, but it could be a stretch. So let's say, yes, they could still be useful if they were purchased independently. Okay, it's still not helping the professional corp here very much, and it does seem like a stretch, so we can change that back. But you get the idea. So what you can do using the software is very rapidly scenario test multiple different changes, variations on the particular situation, and get some comfort around what the result would likely be in a particular situation. Okay, so now we're back here. One of the things that you might do is say, okay, so I really want to find cases where the outcome was not single supply. So if I'm advocating for the professional corp here, I might say, okay, Ben, earlier on in the webinar today, you said you're going to be able to provide, backup or advocacy tools, finding those cases that might allow you to generate the outcome that you want for your client. So what's the best argument for the professional corp here? So we know an independent kind of objective take on the facts here means that this is not looking good for the professional corp. So we'll see here, the best match here is the professional corp case. But what if we wanted to find, okay, so what are the most similar cases where the outcome was multiple supplies? So we can here search for cases by outcome that were multiple supplies, and let's dial up the relevance of that outcome. Okay, so now what we've done is we have located the most similar cases where the outcome is multiple supplies here. It looks like there are 4 of them when we dial up this relevancy. And so let's see what they are. So this Lorraineville and the Queen case from 2003. So very, very interesting. It matches on almost all of the elements. It doesn't match on industry. It doesn't match on the elements were specifically designed to work with the others. And it doesn't match on the actions of direct competitors. So that's interesting, but all the other elements are the same. So if I'm advocating for the professional corp in the situation, my next step would be to click on that case. It'll open it up in TaxNet Pro, which will then allow me to do further research. I'll be able to look at the actual arguments marshaled by the taxpayer in that case, find out what it was specifically about this case that allowed the court to comfortably come to the conclusion that it was actually a multiple supply situation. Maybe I can find an argument that I then might be able to make into something when I'm advocating for my own client here, the professional corp. What about Great Canadian Trophy hunts and the Queen? Same sort of use case here. Kind of interesting. We can click on it. It'll take us out into TaxNet Pro. We can do the normal research that we might do from that point. So that's pretty interesting. What I'd like to do now is clear that. And what if I just wanted to find cases involving the healthcare industry? What if I was just curious? So what's the general outcome of healthcare cases? Here I can jump into a different function here, which is called case analytics. So when I click on case analytics, it very, very helpfully kind of says, okay, at a high level, Ben, there have been 23 cases involving single versus multiple supply involving the healthcare industry. 18 of them have gone the single supply route. 5 of them have gone multiple supplies. So that's really great background information to know if I'm advocating for the taxpayer here, or also for the government, right? So it looks like there's a wind at your back if you're the government in this case, if you're advocating for The professional corp, you're like, okay, so the wind may not be at my back here. So what I might want to do at this point is then click on these multiple supply cases, show them. And I say, yes. Okay, now we're getting all the multiple supply cases first that are in the healthcare industry. So we're matching on the outcome, we're matching on the industry. And so I might want to look at these particular examples and figure out, okay, so what's driving the result in these cases? What's actually happening here that's driving the court to say multiple supplies? And then I might want to refine it, right? So find cases by the number of contracts. So one contract only. Are any of these one contract things? Okay, now we're down to 3 cases that are perfect matches. Healthcare, industry, one contract only, and the outcomes, multiple supplies. Let's see, was there a separate charge for each element? Okay, now we've only got 1 case. And so this looks like it's a ruling document from the CRA from 2010. So I could click on that. It would take me to this ruling document. I could figure out exactly what was going on in that case. So I hope you get a sense now from how this is working that there are multiple different ways to assess a client situation. So just heading back to the homepage here, the classifier you use to get a prediction about a particular factual situation. What is it that's actually is the best prediction about what a court would do based on the facts of your specific situation or your client's specific situation? And so that gives you, a very, very good prediction. What we're finding with most of our classifiers is we're getting around 90% accuracy in predicting out of sample what the courts will do in those actual cases. So there are a couple of different ways how we assess the accuracy of the classifiers. One of them is based on taking the entire set of cases, so the hundreds of cases that go into any one of these classifiers, and then randomly setting aside 30% of those cases, training the algorithms on 70% of the cases, and then taking these 30% of the cases that the algorithms had never seen before and running them one by one past the algorithm, getting a prediction about how a court would decide those cases, and then comparing that with what we know actually happened in the case as the outcome. And what we're finding is we're getting about 90% of those cases right. The other way to test out of sample is to take cases as they're decided. So new cases get decided in each of these categories very, very frequently, which is one of the reasons why, by the way, it's impossible as an accountant or a lawyer to stay up with all the cases that get decided. Nobody has the time to read every case as they get decided. But as these cases get decided, we add them to the databases that we're training our classifiers on. And so we're able to tell at the time that we introduce new judgments as they come down, as they're decided by the courts, and compare them with what the algorithms would have predicted prior to the addition of those new cases as they get decided. And what we're finding is that we're getting 90% plus accuracy. Some batches when we update, we're 8 for 8 or we're 10 for 10 in the new cases that are decided. And so it's really, 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 really exciting to see that there's a lot of litigation that doesn't necessarily have to happen when those cases are predictable. And so one of the things that's happening is that we're starting to see more settlements earlier on in these processes in these areas where classifiers have been built, because nobody wants to take a loser to court. If you're in the government, you don't want to take a loser to court. If you're a taxpayer, you do not want to spend the time and energy, the emotional energy, the resources necessary to take a case to court. Okay, so the classifier is one entry point into figuring out what to do about one of these, difficult to figure out kinds of questions. And make no mistake, the single versus multiple supply question is actually a really tricky philosophical question. You may be thinking, oh, it's not that hard. I know if it's single versus multiple supply, I can read the admin materials. Don't trick yourself. This is actually really, really hard to do. Using the classifier makes it much easier to get a handle on exactly what the courts are doing with different kinds of situations as they come up. Now, the classifier provides this neutral, objective kind of take on the prospects for a particular set of facts if it were to go to court. The case finder is more of an advocacy tool or more of a double checking tool, making sure that you're not missing any cases when you're conducting your analysis. So one of the main deliverables for a client is often an opinion letter of some kind. So why is it that we should take the position that X or Y? The case finder can make sure that you're not missing anything that might be helpful, and you're not missing anything that might be devastating for your opinion. So it's a way to just double check, making sure that you're not losing anything. Case analytics is a way to, at a high level, get some idea about the entire lay of the land and cut the data in various different ways and figure out what the likely outcome would be, paying attention to certain subsets of the information. So at a high level, if you're finding yourself bristling a little bit, and this is not an uncommon reaction about the classifier. Oh, but I don't know if I can trust this algorithm. Think back to when GPSs first came out. A lot of people didn't trust GPSs for giving them proper directions to get to their destination. And a lot of us, when we first installed GPSs in our cars, would just, if we know how to get somewhere, we type in our destination anyway and just see out of curiosity, which way is this GPS going to take me to get to the particular place? And then we'd scoff at it, right? Because we'd say, oh, I know a better way. I know a faster way than the way my GPS is proposing to take me. But now, every time I second guess the directions that I'm getting from my phone, I'm on the road, and these navigational tools now have real-time traffic, and they know a lot more about how to get to where I want to go at this moment than I do. I've learned that if I second guess my navigational tool, that's a big mistake. And so I think we're going to see the same thing with machine learning and predicting outcomes in case law. People are a little bit nervous about these classifiers sometimes until they start seeing them in action, right? And seeing the new cases coming down and going, oh, okay, actually, they are right. In the same way that I get burned when I'm second guessing the directions that I'm getting from my navigation program on my iPhone. But for those of us who are not quite ready to just say, oh, well, this classifier is saying 94% likely it's a single supply, case analytics is very helpful just to analyze, okay, what if we're dealing with healthcare industry, and we've got one contract only, and we've got a separate charge for each element. What do my chances look like? Okay, rough and ready. There have only been 4 of these cases that match, but 3 went in the direction of single supply. So that's not saying it's 94% confident, but casual empiricism suggests that's about 75% chance that's going to be a single supply. That's losing out on a massive amount of information, but at least it's very tangible, right? Because then I can say, okay, just show me these cases, and then I'll be able to read them and check this out, right? So I'd be able to see why that's a single supply case, or I can go back to case analytics, and now it's just got it's only got that one because it's insisting on the outcome. So if I take that off again, if I want to see the single supply ones, I can see the single supply ones, and I can read through these cases, and I can get a sense of, which is the right characterization. I can do my more labor-intensive research, but more grounded in some ways than the classifier. So depending on how comfortable you are, depending on the stage with which you're experienced with using this kind of software, computational software, to figure out how to advise your client, you may find yourself more comfortable with Case Finder and Case Analytics, or you may find yourself more comfortable with the classifiers. And so it really depends. But all the information's here, tons of different ways to cut the information, slice it and dice it in various ways. So I think what I'd like to do now is open it up to questions. And so I believe there's a function, you can type in questions relatively easily here into the system. If you have been attending this webinar and you've stayed right to the end, that suggests to me that you do have an interest in Tax Foresight, or you may be getting the CPD credit. Either way, what I want to do is invite you to send me an email, ben@bluejaylegal.com. I can hook you up with someone who can step you through the software, answer whatever questions you may have at your leisure about the software. You may log out of the webinar. You may be running off to a meeting at 3 o'clock and say, oh, I'm interested in this, but I don't have time to ask questions right now. Just send me an email. I'm happy to put you in touch with the people who can get back to you really, really quickly. If you enjoy getting CPD credit with these webinars, tweet us and you can help out others in your network get CPD credit in future webinars. So this is a regular series. We talk about current cases, cases of current interest, and we also shed some light on how these new tools are going to be shaping practice in the future, both in accounting and in law, and also from the administrative perspective. So it won't surprise you that these tools have immense promise for use in the public sector. So just imagine the government's problem here. So if you're a senior leader in government and you want to make sure that there's consistent decision-making across your agency, it has immense value to be able to make sure that everyone's considering all the right sorts of considerations in making decisions of these kinds. They're discretionary. You can use these kinds of tools to figure these things out. And it also gives an audit trail internally to make sure that the right sort of decisions are being made at the front end. And so in a system as enormous and as complicated as the Canadian tax system, these sorts of tools have immense promise. Okay, so I'm getting some questions here. Okay, so somebody's asked, this looks like an expert system similar to TurboTax. What AI technology is working on the BlueJay platform? So we use a whole bunch of different algorithms, a bunch of different AI technologies, different machine learning technologies. Some of them are homegrown, our own creation. So these are things that we've developed in-house. Other elements of the technology, we're using third-party providers. So there are a whole bunch of different machine learning platforms that are available in the cloud now. So I'll just give you some examples. We're pretty platform agnostic when it comes to the most common forms of machine learning algorithms, but I'll just give you an example, right? These are all the usual big players. So Google has a whole bunch of cloud services that you can access machine learning services from them through the cloud. Microsoft has its Azure machine learning platform. You can access machine learning algorithms through Microsoft. Amazon machine learning is available. And again, these are all using well-known algorithms. What we found is really necessary is to take the best technology available from different providers and assemble them into a complete solution. So TurboTax, for example, is not really AI. That's just a straight up tool that is not using machine learning at all. That doesn't mean it's not incredibly valuable, and obviously Intuit has built an amazing business with TurboTax and providing a convenient solution for taxpayers to comply with their tax obligations. We're using higher order, obviously cognitive kinds of algorithms and machine learning under the hood here to deliver the solution. I'm actually really thrilled that you think it looks as easy to use as something like TurboTax. It's one of the things that we take very seriously, trying to make technology, super sophisticated technology, easy to use and not intimidating to someone who maybe doesn't want to use their own neural networks to figure things out. Okay, question. A few of the examples cited seem to be informal procedure cases, CRA views. Does the tool allow the user to ignore these? In this specific case, how would things look like if we omitted CRA views and informal procedure cases? So what the system does is it's trained on actual court cases. So it's taking as the key things, the actual outcome of cases decided by the courts. We don't draw a sharp distinction between formal or general procedure cases and the informal procedure cases. So that's actually right. One of the reasons why we don't is there's not a significant difference in the attitudes towards by the courts in those kinds of cases. So we've done a whole bunch of diagnostics, and we actually find that it doesn't, in directionality wise, doesn't seem to affect the results significantly, if at all. But what is valuable is to actually get the more information possible into the algorithm, because then it can refine its predictions. So our predictions are based on all the court cases, including informal cases. So that's a legit question. What we're finding is that our prediction accuracy is kind of the same across formal or general procedure cases and informal procedure cases. So not a sharp distinction there at all. So great question. We're now at a time. I see it's 3 o'clock on my watch. I want to respect everyone's time. Thank you very much for tuning in to this webinar. This will be posted eventually online. I do invite you to tweet us out, help other people in your network get their CPD credits. I hope you've found this interesting. I really enjoy doing these things, so I'm looking forward to speaking to you again in a future webinar. Thanks very much. Have a great afternoon, everybody.